He stands, and the room inhales. "I will defend him," Eli Moss says, voice low and steady. His jacket still smells of oil. His hands hold a small, worn bar card. Dr. Daniel King looks up, abandoned, shoulders slumped. His lawyers are not here. Their phones did not answer. The expensive chairs where counsel should sit are empty. No explanation, no notice. A man left to face an emergency hearing without a voice. Rachel Myers, lead counsel for the plaintiffs, straightens like she's been handed the perfect moment. Her smile is thin. The defendant appears without representation, she says, deliberately slow. "We move for a default judgment on our injunction petition. This is a civil hearing, a petition for emergency injunction filed by investors and partners claiming fraud and breach of fiduciary duty. Without defense counsel, Daniel faces an automatic restraining order that would freeze Ethereum's operations, seize its assets, and effectively end the company before the science can be proven." Eli steps forward. He does not shout. He does not perform. He holds the card that proves a life once argued before courts. "Your Honor," he says, "I request permission to serve as emergency counsel for Dr. Daniel King in this civil matter, pro bono, until permanent representation can be secured." Silence. Judge Marta Vale studies him, the bench a plain island of authority. The courthouse leans in because this is a contradiction that demands attention. A maintenance technician offering to stand in for a missing legal team. But this is not just one law firm gone quiet. Underneath the empty chairs are lab notebooks, pilot reactors, nights of tests that turned carbon into fuel. This technology is simple to describe and impossible to ignore. It eats carbon and makes fuel. If this trial folds on a technicality, it won't merely sink a startup. It will let a powerful industry lock the gates on a different future. Judge Vale studies Eli's bar card, then the docket. "Mr. Moss, you maintain an active license?" "Yes, Your Honor, in good standing." "And you understand this is a complex commercial litigation with immediate injunctive relief at stake?" "I do, Your Honor." She pauses, weighing procedure against justice. "I will grant temporary leave for you to represent Dr. King in today's hearing. However, the defendant must secure permanent counsel within 72 hours, or this court will appoint representation. Do you accept these terms? If you're watching now, tell me where you are in the comments. If you believe people should be judged by their actions and not their clothes, drop "I stand" below and hit like. Judge Vale exhales. Eli meets her eyes. "I understand the gravity of this request," he says. Then, with the same quiet certainty, "I will defend him." He moves down the courthouse corridor with a toolbox at his side, checking a loose hinge, tightening a flickering light. The work is exact. It keeps him close to the place he once argued in, close enough to hear the echoes of a life he lost. 20 years ago, Eli Moss stood in this room in a suit, not a jacket with utility patches. He was an assistant district attorney who pushed cases until paper could no longer hide a truth. He believed procedure anchored justice. He believed diligence was armor. In one pivotal hearing, he pressed a clerk for a file that never arrived. He pushed on. That impatience left a hairline fracture. Petrodine's lawyers are experts at finding hairlines. They took a pause, a clipped answer, and turned it into a looped doubt. A public inquiry followed. Not a criminal charge, but enough to make allies step back. Clips of awkward exchanges grew into headlines. The fade was slow, like paint washed away by repeated rain. For Eli, the erosion was audible. Calls at dawn, polite distance from former partners, the sting of edited footage replayed as proof. He felt his authority thin like a rope worn smooth. He kept his license. He kept his standards. He stopped prosecuting because the house that amplified his voice had begun to use it against him. He took maintenance work to be near the law without inviting the public teeth that once bit him. His phone buzzes. Leah's face fills the screen, sharp, tired, already 3 moves ahead. "Dad, cameras are outside," she says. "They're pulling the old hearings." Aaron slides in beside her, steady, practical. "If you do this," he says, "we record every exchange. We prepare statements. Don't let them frame a pause into a scandal." There's a tremor in his voice. Not scientific, but a son asking his father not to be broken again. Eli listens. He remembers the day a newsroom cut an earnest exchange into a smear. He remembers thinking facts alone would win. He remembers being wrong. Then the feed floods. Old footage resurfaces on timelines. A decade-old photo is cropped to suggest a temperament. A 10-second splice is captioned with mockery. The smear moves faster now. Behind the noise, a quieter proof appears. Nina, a digital forensics analyst Eli trusts from a case years back, texts that she traced a payment trail to a PR vendor with ties to Petrodine. The vendor seeded a string of sponsored posts and a sponsored article that pushed the narrative. The pattern is the same playbook, sharpened by money and algorithms. He closes his toolbox and feels the old weight, but steadier this time. Instead of telling himself he must rebuild a name, he does something smaller and harder. He pins a photo to his wallet, a lab shot Daniel had shown him in the meeting, a reactor glowing with promise. He slides the worn bar card over it and tucks both into his palm like a talisman. He does not say that he will save his reputation. He straightens, breathes, and shoulders open toward the courtroom. He will speak because truth deserves a voice, and because some fights are bigger than one man's past. Do you think public opinion can destroy a person? Type yes or no. He stands on the plaza and looks up at the Ethereum tower. Glass throws back the morning sun in clean, confident planes. Valets, security, an immaculate lobby, a place that trades in futures and polished slides. The guard at the gate studies Eli's visitor pass like a problem to be solved. The receptionist asks for ID twice. Her eyes flick to his hands, to the thin bar card in his wallet, then away. 30 minutes pass in small, polite hesitations. The building's welcome is careful. The building asks who he thinks he is. When he finally sits in the temporary conference room, Daniel King watches him with the wary focus of someone who has learned not to waste breath. "Why did you accept to represent me, Mr. Moss?" he asks. Practical, not cruel, a distance check. Eli answers simply, but from a life behind it. "Because I remember what happened when the story got told for us," he says. "I remember men who had proofs in their hands and lost everything because someone else's clip looked truer than their papers. I lost my right to be believed once. I'd rather stand in the room than stand outside and watch that happen again." He does not plead. He states a promise. Daniel slides a tablet across the table. "We've been picked at. Intrusions, anonymous letters, investor pressure. We don't have time for theatrics." His tone is tight. Eli reads for pattern. He is not fluent in chemistry, but he reads timelines and seams. A pilot fermentation log, week 12, shows a neat column of readings and then an abrupt gap. A scanned lab report bears a signature that sits too perfectly on the line. "This was pasted," Eli says, pointing to the pixel edge where ink meets paper. Whoever did this copied an image and pasted it in. It looks hand-signed, but it isn't. Daniel leans forward. We had a failed sync, he admits. We thought a drive crashed. The admission has a tiredness to it. If this is manufactured, it's deliberate. Eli asks direct questions. When were raw logs last exported? Who had night access to servers? Where are physical backups kept? Daniel supplies names, contractors, night techs, an investor who froze funds after an anonymous compliance letter. Each factual answer narrows the distance between them. They agree on next steps, secure hard copies, isolate remaining samples, and bring in a digital forensics specialist. The lab visit is authorized on condition of strict protocols. The next morning, Eli trades his jacket for a disposable gown and gloves. The lab smells of sterilizer and warm metal. The reactor is modest, instrumented, precise, tubing, sensors, labeled sample jars. In a clear sightline, a thin column of bubbles rises, patient and precise. Daniel explains plainly. We feed concentrated CO2 and process gases from partner plants, steel mills, cement works, into a fermentation vessel. Modified microbes ferment that gas into ethanol and other carbon-negative hydrocarbons. The process needs steady feedstock, careful heat control, and strict mass balances. It's been proven at commercial scale in Belgium. Under the right hosts, 30 million gallons a year is realistic. It's engineering, not magic. Eli squints at readouts, asks Daniel to say things in plain language. Daniel shows inlet meters, outlet yields, and stacks of paper-run sheets with handwritten initials. Those initials matter, Eli says. A server can't invent a signature in a notebook. There is a small human moment when Daniel relaxes enough to be plain. If we succeed, he says, it changes who benefits from the air people breathe. That makes it political and expensive to defend. Eli holds the tiny vial of clear fuel up to the light. He does not romanticize it. You built an obligation, he says. People will fight to keep what they earn. Back in a quiet conference room, the plan hardens into procedure. Eli opens his laptop and begins to write. He drafts a motion that is spare and exact, a request for immediate preservation of all server images, backups, cloud snapshots, and physical run sheets, an order for forensic write protection of remaining drives, and a preservation of paid social ad buys and sponsored content related to Ethereum for the past 6 months. He reads clauses aloud as he types, testing the cadence of legal language. This motion will ask the court to prevent anyone from destroying or altering data, he says. It will ask for mirrored images and custody logs, and for preservation of ad receipts and web buys. If the court signs it, we stop the erasure long enough to show what was done. Daniel reads the draft and, after a long pause, signs a letter authorizing Eli to act on Ethereum's behalf. Do what you must, he says. If this works, we may buy the time to prove it. Eli walks to the federal courthouse and files the motion at the clerk's window. The clerk stamps the packet, assigns a case number, and says an emergency hearing will be set. A court clerk's voice, dry and procedural, tells him that Judge Marta Vale will be notified, and a preservation hearing scheduled for the following morning. He steps outside the clerk's door and breathes in the courthouse air. For the first time since he volunteered to defend Daniel, the fight has a date. The work moves from private suspicion into public procedure. The stakes feel larger in the way only a calendar and a judge's attention can make them. Outside, the tower sends back the city's light. Inside, the reactor pulses in quiet blue, patient as proof. A small coalition now exists: paper, forensics, a scientist, and a man who remembers how to make systems answer for themselves. If microbes can turn industrial emissions into usable fuel and shift who benefits from the air, should the world protect that work? Comment yes or no. Nina Park and Aaron arrive, moving like people who have lived inside server rooms for years. Eli introduces them to Daniel in a small conference space, laying out the limits: supervised access, signed non-disclosures. Daniel, still cautious, signs the authorizations and watches the door. The first day is methodical and slow. Nina images drives in a controlled room while Aaron catalogs paper run sheets in another. Nina explains what she will do in plain terms. I'll make an exact copy of the drives that can't be changed. Think of it like photocopying a sealed book. We keep the copy sealed so nobody can pretend pages were different. Then we create a digital fingerprint called a hash. If anyone changes a byte later, the fingerprint won't match. Eli nods and writes the word hash on a pad, not to show he understands every byte, but to keep the guardrails straight for the court. The work is not a single breakthrough. Difficulties arrive like persistent storms. An encrypted container resists mounting. A backup drive stored in humidity requires careful stabilization. Each setback forces a cautious restart. Aaron, who knows fermentation but not drives, watches Nina's patient work with respect. Progress is measured. Nina produces a list of image hashes and timestamps. Aaron produces a reconstructed table from Slackspace, a version of a fermentation log that no longer exists in the public folder. The reconstructed table contains inlet CO2 numbers, outlet yields, and handwritten initials that match a physical run sheet Eli has already seen. Aaron explains the point simply. If incoming gas and outgoing fuel numbers tally under mass balance, the run is real. If they removed those rows from the report, they change the story. Eli does not try to explain the code. He frames the facts. He asks strategic questions. When were these backups made? Who physically moved them? Which vendor tokens were active on the nights the gaps appear? Nina answers without jargon. The edits originate from a route that masks its starting point, like someone sending a letter through 3 different P.O. boxes to hide where it began. Aaron adds, "We recovered a copy from unallocated disk space, evidence that the original existed and was altered. There are dead ends. A vendor ID leads nowhere. An access token maps to a former contractor. Each failure is documented, requiring new avenues like subpoenas and certified letters to vendors. They transform technical outputs into sworn statements. Nina drafts an affidavit explaining her methods in plain language with diagrams and hash strings. Aaron's affidavit lays out the reconstructed run and how mass balance proves authenticity. Eli converts these into a concise legal memo linking method to admissibility. Preparing for court is itself a series of small rehearsals. Eli reads aloud Nina's affidavit until the cadence is exact. He practices asking the narrow questions that tie the tech facts to legal standards. He will not be the expert on the stand. He will call Nina and Aaron and use their sworn words to build the legal frame. At the courthouse, the morning of the preservation hearing moves with brisk, quiet formality. Defense counsel, representing outside interests that have pressured earlier investors, rises on principle. The motion is overbroad. It risks chilling speech and commerce. Eli listens. He speaks last, the measured voice of someone who has spent years in rooms where facts mattered more than spin. He puts Nina and Aaron forward. Nina, under oath, explains her methods using simple metaphors. Routing is like a package sent through many P.O. boxes, and a hash is like sealing a book with a wax stamp. Aaron follows, keeping his testimony simple. Inlet numbers, outlet yields, and technician initials on the recovered backup match the paper logs. He shows the judge side-by-side comparisons, demonstrating how the straightforward math of mass balance proves the run was real. Defense counsel counters with skepticism. "There are gaps," the attorney says. "We cannot assume bad faith from an edit. Systems fail. Synchronizations fail." The lawyer raises the specter of chilling consequences if the court freezes too much. The exchange is technical but brief, and Judge Marta Vale keeps the questions tightly procedural. How intrusive is independent imaging? Can operations continue? Will preservation be narrowly limited? Eli answers with the authority of procedure. He summarizes the affidavits: narrow scope, immediate need, minimal operational disruption. He proposes an independent, court-appointed forensic firm and limited preservation, image the identified drives, sequester copies under court seal, and preserve transactional ad receipts for a defined window. He stresses that this is not censorship. It is a freeze on destruction. Judge Vale considers the balance. She rules she will not police discourse, but she will prevent destruction of potential evidence. She signs a preservation order that appoints an independent forensics firm to image specified drives, requires immediate right protection, and directs preservation of ads and sponsored content receipts for 6 months. The court orders detailed documentation of every step. It is a narrow victory, but a crucial one. The order does not prove motive. It buys time and force matches facts that can be tested. Back at Ethereum, Nina hands Eli the printout of hashes. Aaron copies sealed images to an air-gapped drive. Eli pins the new timeline to the wall and draws a clean line, from missing rows to sealed evidence to a judge's order. The path forward will be tedious and slow, but it now exists under law, not just conjecture. Tag someone who believes careful preservation of digital evidence can let truth out of noise. The first clip drops on a Monday morning, a 10-second edit of Eli Moss at the courthouse. His hand raised mid-sentence, his face frozen between concern and fatigue, now overlaid with a mocking caption: "From mops to motions, meet the janitor lawyer saving the world." They call him a janitor. It's easier to mock a man than to understand him. Within hours, it spreads. The cut bleeds into another edit. Daniel King in a lab coat, the audio spliced so his technical explanation sounds like a confession. Hashtags bloom: fake fuel, eco-fraud, Ethereum hoax. Anonymous accounts post side-by-side videos with bright emojis, calling it proof. The clips are short, vicious, and designed to tire people into indifference. Eli doesn't have a feed, but Leah calls before sunrise. "They're everywhere, Dad," she says, scrolling. "They used footage from your hearing. They've tagged you in every conspiracy thread." Eli listens, and the question he asks is practical. Who paid for it? By noon, the PR team brings a new problem: a long-form investigation on a business site written under a freelance byline. The article's headline reads, "The Truth About Carbon-Eating Bacteria, a billion-dollar lie." It quotes unnamed insiders, claims regulatory violations, and ends with a line that smells like triumph. Transparency is not suppression, It's sunlight. Nina scans the byline and frowns. This domain was registered 3 weeks ago, she says. The payment processor matches one used by a PR vendor we found in the ad data. Aaron, running ad trackers, adds, they're buying targeted boosts, investor markets, trades, and opinion hubs. Daniel leans back, pale. They're trying to make our science look like scandal, he says. Eli looks at the folder of clips and screenshots. They don't want truth, he says. They want fatigue. If the story is loud enough, no one checks the record. He closes the folder. We're not fighting the press. We're fighting the infrastructure behind it. That afternoon, he files an emergency motion, not for takedown, but for traceability. The 3-page request is simple. Preservation of ad receipts, invoices, and the identities of accounts that purchased targeted promotion of the smear content. It asks the court to compel platforms and vendors to preserve the transactional records before they vanish. In court the next morning, Judge Marta Vale listens. Petrodyne's counsel rises to object. This is the digital town square, the lawyer says. My client cannot control independent journalists. To restrict content risks chilling speech. The First Amendment is not a convenience clause. Eli stands with a simple legal pad. He does not plead censorship. He points to Nina's affidavit linking ad IDs to a PR vendor and Aaron's data showing geo-clustered boosts. These posts were paid and scheduled, he says. They are not organic speech. Discovery into ad buys and invoices is necessary to understand who financed this noise. Defense counsel clicks play. The courtroom fills with a distorted clip. Eli's voice truncated, Daniel's lab snippet rearranged, a mocking caption. Satire, the lawyer says, unpleasant but lawful. Eli listens, then speaks to the narrow point. We ask only to preserve transactional records data. Invoices, ad receipts, payment routing. If these were purchases, they leave a paper trail. He frames the motion as a pause to protect evidence, not a gag. Judge Vale considers scope and harm. She will not order content removed, she says, but she will not allow evidence to vanish. The court grants limited discovery. Platforms must preserve ad buys, payment receipts, and promotional metadata related to the campaign. Compliance within 10 days. Nina adds one more, low and precise. I flagged an internal account used to transfer files on the nights we saw data gaps. That's a clue we'll need to follow. Outside, reporters pester and push narratives. One camera asks, Mr. Moss, are you trying to silence the free press? Eli answers simply, no, I'm trying to keep evidence from being buried under it. The soundbite runs uncut that night. Back at Ethereum, they start mapping the discovery, vendor names, payment processors, promoted posts, and the ad IDs that match the timeline of the smear. The map grows, money, amplification, targeted audiences. Nina says quietly, the harder they push, the more fingerprints they leave. Eli pins the first nodes to the board. The next fights will be subpoenas and depositions, not feeds and rage. For the moment, the court has turned noise into a possible paper trail. Tag someone who believes the truth deserves more than a trending hashtag. The smell of smoke greets them before the sirens die down. Aaron's voice is raw on the line. South Bay, prototype. It's gutted. Frames melted, coil housings, all gone. By the time Eli arrives, fire crews are packing up. Ash flakes off concrete. The sprinklers hang limp. A guard shrugs. The cameras went dark at 0013. No footage, no answers. Just a scorched footprint, where careful experiments used to hum. Daniel stands near a ruined crate, rubbing soot from his hands. It was in the prototype bay, he says. Suppression was cut at the source. His voice is flat with practical hurt. Nina arrives with a laptop case and a face set to work. My inbox lit up at 3 a.m., she says. Anonymous. Stop digging. Not funny. Aaron shows a note tucked under his windshield wiper. Your family would be better off if you let it go. Eli hears the pattern. Threats that start as whispers and escalate into sabotage. He writes a motion that night, protective order, immediate, not for vengeance, but to keep people safe and evidence intact. At the courthouse the next morning, Judge Marta Vale listens while Eli lays out the facts. Photos of the fire, Nina's emergency emails, Aaron's statement about the note, and Daniel's inventory of the destroyed prototype. Eli asks for two things: protection for witnesses and supervised inspection of a warehouse Etherian used for prototype staging. You seek both a protective order and a search warrant, the judge says. Explain why both are needed now. Eli answers plainly. Since the preservation order, there has been a pattern: data gaps, anonymous warnings, and now physical destruction of a prototype tied to preserved evidence. We ask for protection of witnesses and supervised inspection of the warehouse where remaining records may be stored. We request U.S. Marshal supervision for safety and legitimacy. Defense counsel objects. Fires happen. Notes are pranks. Judge Vale studies the folder, then signs a narrow, deliberate order. Protective measures for named witnesses and authorization for a supervised warehouse search within 48 hours. Overnight, defense counsel files a procedural response, a motion questioning potential conflicts tied to outside donations to a fund associated with the presiding judge. The calendar shifts. The court warns parties the hearing schedule may be reassigned pending review. The warehouse sits 20 miles out, low concrete, rows of crates, and the smell of old diesel. Two marshals stand by the roll-up door as Eli, Daniel, Nina, and Aaron step inside with flashlights. Dust hangs in their beams. They work carefully. Marshals log every crate opened. Nina photographs serial plates. Aaron cross-references packing lists. Most crates are mundane: spare hoses, labeled fittings, insulation foam. In a corner, beneath a toppled pallet, they find binders with heat-darkened edges, purchase orders, vendor invoices, stamped receipts. The binders are not a smoking gun. They are messy, partial, realistic. Several invoices point to Harrow and Locke Consulting, a small consulting firm. Amounts repeat in rhythm with prototype shipments, consistent, but not decisive. Daniel leans over a page and traces a faint stamp. He stops. Project Triton, he says. That was our internal tag for sub-assembly runs. The recognition changes him. He calls a manufacturing partner to confirm shipping dates. The call confirms a pallet left a terminal linked to a Petrodyne-affiliated logistics handler on a date matching a missing lab run. Alignment, not proof, but alignment matters. Nina photographs the page. It's not Petrodyne on paper, she says. It's a consultant. Consultants can route funds and obscure beneficiaries. We'll need subpoenas for banking records. She taps her tablet. This is the start of a chain, not a confession. They bag and label everything, time-stamped and witnessed. Nina notes some pages will need forensic enhancement to reveal soot-obscured numbers. Some routing codes may need lab imaging to read. Back at Etherian, Daniel is quieter, but more present. He moves through his team differently, calling partners and confirming manifests. He presses a hand against a charred binder and says, "We'll force the record." Eli files a follow-up report with the court, the supervised search results, a catalog of seized items, and requests for subpoenas for Harrow and Locke and the logistics partners' bank records. He asks the court to order forensic enhancement of the most damaged documents. His filing is spare, factual, and designed to survive scrutiny. That night, Nina emails, "We saved what we could. Some pages legible, others need lab work. This is a trail, not a reveal." Aaron texts, "Prototype was fragile. We'll rebuild. Keep everything off the cloud." Daniel drops a charred binder on Eli's desk and, for the first time since the fire, speaks plainly. "I helped design that part. I thought partners would respect it. I didn't expect sabotage like this." He looks at Eli. "We'll get it back." Eli pins a new timeline to the wall. Missing rows, sealed evidence, martial logs, and court orders. The preservation order and the protective order hold them together for now. They have not found Petrodine's name printed in a ledger. They have found the architecture someone used to hide it. Consultants, logistics, escrow accounts. That architecture can be traced. Outside, the city hums. Inside, the team breathes the quiet after a hard day. The real work begins. Subpoenas, bank traces, and forensic imaging to coax numbers out of soot. The fight will be slow and procedural, and for now, the law is their shield. Share. If you believe those who risk speaking truth deserve legal protection. The courtroom has a new name on the bench, Judge Connor Hale. The reassignment followed a defense motion questioning the previous judge's ties, a procedural move that gave the case a sterner hand. This is still a civil trial. Etherean and Dr. Daniel King suing for fraud, tortious interference, and conspiracy. But the stakes have shifted. The evidence Nina and Aaron uncovered has attracted federal attention. Prosecutors are watching. What happens here will determine whether criminal referrals follow. New judge, new expectations. Eli stands with a neat folder. He has rehearsed the sequence. Technical testimony first, legal framing second, witnesses last. He does not need to dramatize. He needs the law to follow the trail. Nina testifies under oath, her explanations short and vivid. She shows a timeline, starting with a user ID, seeking admin. "We traced edits to a masked origin," she says, "routed through a shell company to a consulting firm, Harrow and Locke." She presents a simplified flowchart. The payments to Harrow align with crate movements. From there, funds were routed through intermediaries, eventually clearing into an account linked to Petrodine's logistics partner. It's a chain of intermediaries used to conceal the final beneficiary. Aaron follows, and his testimony is spare and plain. He explains mass balance in 2 sentences and lays out a side-by-side, recovered raw runs versus public reports. The raw backups we recovered contain inlet CO2 readings, outlet yields, and technician initials. Those rows are absent from the published files. He points to the printed hashes on the screen. Independent imaging verified the copies. These are not forgeries of a single file. The pattern repeats across multiple runs. Defense counsel rises, his voice smooth. "We do not deny there are files. We deny that they were manipulated with malice or that these links demonstrate wrongdoing by our client. Metadata can be messy, chains can be indirect. We move to suppress on authenticity and prejudice grounds." Eli does not make the technical argument. He calls Nina back to the stand and directs the inquiry to the chain of custody documents, martial logs, imaging certificates, witness signatures, and the independent firm's affidavit. "You imaged the drives under martial supervision?" he asks. "You created write-protected images and recorded hashes?" Nina confirms. Each step is backed by a signed entry. The paper trail is dry and tight. Judge Hale listens and then asks to hear from a human source whose voice might fill gaps the logs cannot. A corporate assistant who appears on video deposition, Olivia Price. She sits remote, hands folded, eyes rimmed with exhaustion. This is the first public moment Olivia has agreed to speak. Her counsel negotiated protection and limited scope. She is nervous. When she begins, her voice is low. "I forwarded files," she says. "I was given an alias to send to, told it was for compliance. I was told to mark things as investor ready. I did not know the material would be edited and pushed as a campaign." She pauses. "I thought I was protecting partners. Later, when I saw clips, I was shocked. The defense objects to hearsay, but Judge Hale allows the deposition's limited use as corroboration of process and intent. Her words are not an indictment, but they are human corroboration. They connect the technical trace to a person who, under pressure, followed instructions that looked administrative. The effect is subtle, but powerful. The logs now have a human hand behind them. Now, Eli asks for the name that the logs hinted at earlier. The clerk calls Caleb King. He walks in stiffly, younger, glossy, a man who is not expected to be here. He swears an oath. The room settles. Caleb's lawyer sits beside him, tight-lipped. Eli's questions are short and clear. "Did you, at any time, use a contractor token to access the directories containing lab reports?" Caleb's jaw tightens. "Yes." "Did you forward files to an external address under instruction?" He looks down. "I forwarded files to an address I was told would help secure hosting partners." His voice is thin. "I thought if I kept deals alive, the company and the people here would be safe." It is not a clean confession. He denies orchestrating a smear campaign, admitting only to poor judgment under pressure from investors and looming deadlines. "I was told to help," he says, his voice thin. "I thought I was protecting family." Daniel watches from the gallery. The expression on his face cracks the courtroom's formal calm. Disbelief, betrayal, sorrow. This is the human cost of compromise. The judge allows a short, carefully managed cross-examination. Defense counsel frames Caleb as pressured, not malicious. Eli frames him as a node in a larger architecture of concealment. Defense counsel moves again to suppress, arguing that admissions are ambiguous and chain of custody remains contested. Judge Hale hears the technical rebuttals: independent imaging, hashes, martial logs, and Olivia's corroboration. He listens to the balance between reliability and prejudice. His tone is measured. "This court has been presented with verified forensic imaging, chain of custody logs, and corroborating testimony. On admissibility, the evidence is sufficiently reliable. Admissibility is not proof of guilt, but this matter will be referred to the appropriate authority for potential criminal inquiry." A room of restrained breaths exhales. The ruling does not pronounce guilt. It opens a doorway to criminal process. For the first time, the matter moves beyond civil discovery into a realm where subpoenas, grand jury queries, and criminal investigators can pursue the architecture Nina traced. After the hearing, Daniel meets Caleb in a corridor. No shouting, just the quiet fracture of trust. Caleb's apology is tremulous. "I thought I was protecting us." Daniel's reply is quieter than a headline. "You let us down." Eli watches, knowing the legal work succeeded, but that the path forward will be slow and painful. Outside the courthouse, cameras flash. Headlines later that night read, "Evidence admitted, case referred to investigators." Social feeds explode with takes, some calling for mercy, others for accountability. For Eli, the victory tastes like ash. For Daniel, it tastes like a fracture he must navigate. For the team, it is a necessary step. The code's traces led to human choices, and the law has decided those traces deserve investigation. Would you forgive a family member who betrayed you under pressure? Comment below. The courthouse feels heavier today, not louder, but older, as if the walls remember everything that has ever been said in the name of truth. Judge Serena Park enters quietly, her robe moving like a slow exhale of authority. She glances down at the docket, then to the rows of lawyers and cameras. Her appointment followed a procedural reassignment, after defense counsel filed a motion questioning Judge Hale's past affiliations. The chief judge reassigned the trial to Park to avoid any appearance of impropriety. Hale had presided over the discovery phase. Park would preside over the trial, what everyone now calls the reckoning. This is the final stage of the civil case. The jury will decide. Did Petrodyne and its affiliates engage in fraud, sabotage, and conspiracy? The evidence is overwhelming. But more importantly, federal prosecutors are ready. Whatever this jury decides, criminal indictments may follow. Before testimony begins, the clerk reads a procedural note. Caleb King, having entered a cooperation agreement with federal prosecutors in anticipation of criminal charges, will not appear as a live witness in this civil trial. His recorded statement and authenticated emails are entered as Exhibits 32 through 35. A murmur ripples through the courtroom. Caleb's cooperation has become part of the file. Not redemption, not condemnation, just evidence. At counsel's table, Eli Moss adjusts his papers. His hands are steady, his eyes thoughtful. The court's record already knows his title, Civil Counsel for Aetherian Bioworks. But few in the room remember that 20 years ago, he was something else. A prosecutor who lost everything after taking aim at Petrodyne. The same name that now sits quietly on the defense table, masked behind subsidiaries and consultants. He doesn't speak of it yet, but it hums beneath every motion he files, every breath he takes. Judge Park looks to him. "Mr. Moss, the floor is yours." Eli stands. "Your Honor, before I begin, one clarification. This is a civil trial for fraud and conspiracy. However, the evidence we present today has drawn federal interest. I appear as civil counsel for Aetherian and Dr. Daniel King. Federal prosecutors are monitoring this proceeding and, depending on the outcome, may pursue criminal charges independently. I am not here as a prosecutor. I am here as a witness to continuity, a case that began 20 years ago and was never given the chance to finish. I am not here as a prosecutor. I am here as a witness to continuity, a case that began 20 years ago and was never given the chance to finish." He pauses. "The record we present today isn't revenge, it's completion." Judge Park nods. "Proceed." Nina Park, no relation, takes the stand first. She testifies with precision, her voice clipped, clear. "We created forensic images of Aetherian servers under martial supervision," she says. "Each image bears a 256-character hash, verified independently by the court's appointed lab. None diverged. What we preserved is exactly what we recovered." She projects a split screen, one side showing hash strings and timestamps, the other showing metadata logs, the path through proxy hops, the shell company, the edits. Each modification, she explains, was inserted through an external IP now traced to Harrow and Locke Consulting, a middleman used to reroute payments and mask digital origins. Defense counsel objects. Correlation is not causation. My client operates thousands of vendors. Judge Park interrupts, cool and decisive. Objection noted. The court will weigh probative value. Nina continues. We cross-checked payment records recovered from the warehouse. The same firm, the same date, same transaction ID. The pattern repeats. This is not random traffic. It's design. Then comes Aaron. Calm, methodical. He holds a vial of ethanol, sealed and tagged. This is the output from the final verified run, he says. Chain of custody confirmed by the court's independent lab. He shows the lab report. Carbon-negative ethanol, verified purity, consistent with industrial standards. The data matches, Aaron says. The chemistry matches. The science holds. Defense rises again. We contest the integrity of the samples. There were storage delays, chain gaps. Eli cuts in. Every sample was sealed under marshal supervision. The chain is complete. We welcome independent retesting. Judge Park glances down at her notes. The court recognizes authenticity pending cross-verification. Olivia Price testifies next, the assistant who once forwarded files to compliance. She's visibly nervous, but resolute. I sent files I was told to send, she says. I believed it was routine. I didn't know they'd be altered for public spin. Defense objects to subjective belief. Park overrules. It goes to intent and process. Olivia's testimony bridges the human gap between data and deception. Her trembling hands on the paper logs, initials, signatures, become living proof of a system that expected obedience more than honesty. After the witnesses, Eli stands again. The court allows him brief remarks before closing evidence. He speaks not as a litigator, but as a man reclaiming his own record. Your Honor, I once brought a case tied to the same patterns of influence, the same corporations, the same names. I lost that case before it began. I lost my post. But the facts didn't change. They just waited. 20 years later, those same forces stand before you, dressed in newer suits but powered by the same money. This trial isn't about punishing the past. It's about proving that the truth we bury doesn't stay buried. It waits for someone patient enough to dig again. His words hang in the still air. Defense counsel tries one last attack. Your Honor, this case risks overreach. Public policy, not evidence. Judge Park replies calmly. Then policy will answer later. Evidence answers now. She reviews the exhibits one last time. The court finds the digital, scientific, and testimonial evidence sufficiently authenticated and materially relevant. The motion to exclude is denied. Turning to the jury. Ladies and gentlemen, you will now deliberate on whether the defendants are liable for fraud, conspiracy, and tortious interference. Turning to the court reporter. This evidence will also be preserved and transmitted to the United States Attorney's Office for review of potential criminal violations. The question of civil liability is yours to decide. The question of criminal guilt belongs to another proceeding. Her gavel falls, a sound like punctuation at the end of 20 years. Outside, microphones blur together in the noise of press. A federal prosecutor steps to the podium. The Department of Justice is expanding its investigation to include potential corruption and undue influence within energy regulatory bodies. We will follow the evidence, wherever it leads. In that one line, the story changes scale. From a courtroom case to a national inquiry. The name Petrodine appears again, not as a defendant, but as a shadow behind a system. Later, in the hallway, Daniel catches up to Eli. "They'll drag you through it again," Daniel says. Eli smiles faintly. "Maybe, but this time I have the record, and I'm not alone." He steps outside into the pale light, the kind that makes old marble shine like new beginnings. For the first time in 20 years, he doesn't carry silence. He carries proof. 20 years ago, they buried a case. Today, the ground moved. Truth doesn't vanish. It waits for law, for courage, for someone who refuses to stop showing up. Do you believe a court can still correct the mistakes of history? Comment below. The civil jury deliberated for 4 days. When they returned, the verdict was unanimous, liable on all counts. Damages awarded to Ethereum, $47 million. Punitive damages, $120 million. But the money was never the point. Within hours of the verdict, the evidence was transmitted to the United States Attorney's Office. The case that had been civil was now something more serious. The next phase would not be about liability. It would be about crimes. The next phase does not arrive with fireworks. It arrives in envelopes and subpoenas, in a low-lit conference room, and the quiet clack of a court clerk's stamp. When the reckoning steps outside the courtroom, it works with paper, procedure, and patience. U.S. Attorney Claire Morales announces the next phase with 3 sentences. "We have received a federal referral. We will convene a grand jury. We will follow the money and the influence wherever they lead." The case shifts from forensics to corruption. Eli is not in charge. His role is to connect witnesses and keep things human, knowing that institutions are often held together by small, boring things: invoices, wire transfers, dinner receipts. The team starts with bank traces. Nina and Aaron work with prosecutors to translate hashes into human transactions. They map transfers, harrow and lock. Consulting receives a series of payments timed to prototype shipments. From Harrow, sums move through an escrow account into accounts labeled with logistics partners. Those partners, in turn, route small disbursements to a network of vendors, PR firms, shell payrolls, and a legal compliance company that, on paper, appears to consult for regulatory alignment. A compliance officer, after long hesitation, agrees to talk. He pulls up a redacted ledger. "Look at tranche 5, he says. "Small, regular transfers under reporting thresholds. That's the point." His finger traces the wire path: Harrow, escrow, logistics, vendor. "Those last legs," he says, "are the ones you subpoena. Subpoenas come like winter. Invoices are produced. The compliance office of a state regulatory agency turns over meeting calendars. The calendars are empty in ordinary places, but in marginal notes, handwritten, hurried, there are dates and shorthand. June 12th, meeting, discuss guidance delay. An internal memo from a regulatory official named Roger Bell has a line that makes the room go very still. Coordination with partners advised. Delay public guidance until Q4. The memo is unsigned. It is, however, timed the week before a smear campaign spiked. That is where Margaret Lee enters. Quiet, deliberate, and very afraid. She used to work in the environmental division of the agency that monitors industrial emissions. She left 3 years ago under pressure. She does not want cameras. Prosecutors arrange a safe room with soft coffee and softer light. Eli sits in the corner, not to speak, but to listen. Margaret's voice is low. They called it partnership, she says, but the meetings changed. Hold guidance became the phrase. Buy us time was another. She recalls an outside consultant telling her, "You know how this works, Margaret. Jobs matter." She passes a folder containing emails and a receipt for a dinner with Harrow and Locke listed as a vendor. Her testimony does not convict anyone on its own, but it gives motive a face. It shows how business jargon, partnership, pilot, morphs into pressure. It explains why a regulator might slow a ruling, why an inspector might look the other way. The team pairs Margaret's narrative with meeting notes recovered from an executive assistant at Petrodyne, who had, for reasons of conscience or fear, kept copies. Those notes are bland at first glance. Names, times, follow-up. But one entry stands out. Discuss approach to neutralize Ethereum narrative. Coordinate with PR vendor. Ensure technical rebuttal released ahead of public hearing. It reads like a plan, not a memo. The PR vendor, when subpoenaed, produces invoices that match the ad IDs Nina traced earlier. Under pressure, they turn over an internal Slack log. One message is damning. Deploy edits at Aero 800, boost to investor clusters, push safety concern headline. Another confirms, funds from client X via Harrow, processed. The confidence is casual, damning. Prosecutors assemble the pieces like a cartographer. Wire after wire creates paths. Meeting minutes add motive. Whistleblower testimony provides color. A grand jury is sworn in. Subpoenas are issued for bank records, corporate minutes, and the calendars of several mid-level officials at the regulatory agency. There are late nights and sealed rooms. The grand jury weighs documents and calls witnesses. The atmosphere is methodical, almost bureaucratic in its relentlessness. When the panel decides to seek indictments, the decision is not theatrical. It is the quiet click of a mechanism that has been set in motion. Then, one night before dawn, vans roll quietly through the city. Agents in plain clothes approach a downtown office building. A consultant's car is met at the curb. A logistics manager is asked to step outside. By morning, two men in cuffs are led out under a police light that makes their faces pale. The press photographs the moment, but the real action is in the sealed indictments that follow. Counts for conspiracy to obstruct an investigation, wire fraud, and schemes to corrupt. Eli watches the headlines the next day with a strange mix of relief and grief. He is not triumphant. He knows indictments are only allegations. He also knows the mechanism worked: paper, procedure, prosecution. Margaret Lee is not free of fear, but she is steadier. The banker who testified goes back to his desk, smaller now, but honest. The department announces that more subpoenas are pending. The grand jury will continue. Petrodyne's board calls emergency meetings. Stocks wobble. The company issues a terse statement: cooperation. Behind the terse lines, the architecture that protected the old order begins to creak. Eli walks into the small conference room the team uses for debriefs. He looks at the map on the wall, the wires, the invoices, the calendar notes. For 20 years, he carried a private question: who benefits when truth is muted? Now, in columns and dates, the answer is less private and more prosecutable. He says nothing for a long minute, then looks at Nina and Aaron. "We did what we could," he says. "Now let the system do its part." They have opened a door the size of an institution. Walking through it will not be clean or quick. But for the first time in decades, the path is not blocked by silence. The morning the sealed indictments were unsealed, the indictments were the fruit of the civil case. Every piece of evidence Eli, Nina, and Aaron had preserved. Every hash, every invoice, every whistleblower statement had been handed to federal prosecutors. They had built on that foundation, adding wiretaps, financial subpoenas, and cooperating witnesses. The civil case had proven liability. The criminal case would prove crimes. The city woke to a different kind of noise. Not the bright chime of breaking headlines, but the low, persistent sound of consequences arriving. Vans had rolled at dawn, names were called. 2 consultants, a logistics manager, and a mid-level regulatory official were charged. The grand jury's work had moved from paper to process, and the structure that had protected the old order began to shift under its own weight. Petrodyne's stock flickered, then fell. The boardroom issued a terse statement promising cooperation. The word restructuring appeared in filings. It was the start of something larger. A company that had relied on influence to quiet competition suddenly found itself in the long light of public scrutiny. Eli watched the coverage from a small hearing room where he would testify before a federal oversight committee. The invitation surprised him and humbled him. The committee wanted to hear not only the forensics, but the story that had begun 2 decades earlier, how a young prosecutor raised alarms and got the door closed in his face. They wanted context for a national lesson about capture, conscience, and the cost of truth. He sat under lights and microphones and told the simple story. He spoke of hashes, charred binders, and the smear campaigns. Then he spoke of the thing he had carried the longest, the day, 20 years ago, when he lost his name to a headline after an accusation that was never properly vetted. "If you ask me why I stayed close to the law after that," he said softly, "it is because I believed that procedure, when it works, can correct the errors of men. Sometimes justice is loud. Often it is patient. I chose patience." His words were not an appeal for pity. They were a lesson in resolve. The committee listened. Some members nodded, some did not. But the hearing did what it was meant to do. It put a human timeline beside a ledger. It let the public see the human cost of institutional capture and the difficult, slow arithmetic of undoing it. Meanwhile, Daniel King and his small team were doing work that resembled optimism. Rather than retreat into secrecy, Ethereum Bioworks went public in a new way. Daniel announced a deliberate shift. The core fermentation process and run data would be shared openly with vetted partners, nonprofit research networks, and municipal water initiatives. Ethereum would license the technology under terms designed to prevent monopoly control. The goal was not profit maximization, but deployment. Communities that needed clean, local fuel alternatives would have access. The move was radical, resetting the moral ledger. Technology that threatened entrenched revenues would now be open to the communities most harmed by them. Newsrooms called it open source salvation. Eli Moss, who had watched her father carry a private burden into public work, wrote the piece that settled in the public imagination. The Man Who Fought Twice. Her article threaded the 2 timelines, Eli's loss and Eli's return, and made the story feel less like a scandal and more like a lesson. She quoted Judge Serena Park's measured line from the ruling, "Authenticity is not sentimental, it is traceable." Leah's piece ran widely. It turned the morality of the case into a conversation about repair. Small, concrete signs of restoration followed. The state bar, after reviewing the court's findings and the long record of Eli's professional conduct, issued a symbolic letter, a formal reinstatement of standing with an apology for the administrative errors that had shadowed his career. It did not erase the 2 decades he had lived with diminished standing. It did, however, restore his professional identity in a way that mattered to other lawyers, to colleagues, and to a son and daughter who had watched. Judge Serena Park, in her brief public remarks at the close of the year, quoted an unlikely source, Eli. "We apply the law not to rewrite the past, but to prevent its repetition," she said. "We are accountable to facts and to the people who must live with their consequences." Her words were not a personal balm, but they carried weight, the institutional voice that can make a private truth feel public and teachable. Months later, a letter arrived at Eli's small apartment. The envelope was simple. The return line read, "School of Law, visiting lecturer." The offer invited him to teach a seminar on evidence and ethics, not as a celebrity, but as someone who had lived the consequences of doing the right thing when it was costly. He read the letter twice, then 3 times. He thought of the burnt binders, the long patience, and the small coalition of people who had finally told the truth. The invitation felt less like an offer and more like a responsibility. On the day he walked onto campus, the sky was a thin, honest blue. He held the letter in his hand, small and real. Students gathered in a modest classroom. Some were young, eager. Some carried the world-worn look of older students who had worked and saved to begin again. He did not preach. He taught method, how to follow paper, preserve evidence, and ask a question that doesn't let an answer hide. He taught that justice is rarely clean, but showing up matters more than outrunning fear. At the semester's end, an old colleague sent a short note. "Your license is back where it belongs." It was a small sentence. It felt to him like a door held open. The case would not end in a tidy soundtrack. Indictments would wind through plea talks and trials. Petrodine's leadership would be reshaped by legal reckoning and market forces. But a different arc had begun. Truth that was prolonged had finally found a process. A technology once threatened had new life. A man who had been pushed aside found a platform to teach the next generation how to find facts and to keep them safe. Eli stood outside after his last lecture, the campus quiet at dusk. He held the invitation letter in one hand and watched students file past, bright and unfazed. He did not feel like a victor. He felt like someone who had kept a promise to himself, to stand where truth needed time and to let law finally do the work it was meant to do.